Um, there we go. Thank you, Mr. Smith. Is Miss Boyden a member of the public? I'm not sure why she's a participant.
I'm just curious.
Can we please put her in the...
Mayor, this is a meeting, not a webinar. This is the...
Oh, I see. So folks everybody can we mute those that are not the primary?
I think we need to read in a statement to have them, observe but not participate. And then there's nothing much we can do other than the host can mute them as they come on.
Okay, well, if you could do that, if you could mute everyone other than Councilmember Shepherd and
Call me.
All right, Jody, can you make me a host, please?
So for some reason they're going after this woman and what's that? It's like,
if there are any participants or visitors to this meeting, if you would please turn off your camera, we would appreciate it. Only the participants in the actual meeting should have their video on.
Okay, I have it as 1 o'clock. So if the parties are ready, we'll get started. This is a hearing. This is an ethics hearing in the matter in the in re ethics complaint against Councilmember Peggy Shepherd. It has been conducted pursuant to Snoqualmie Municipal Code Section 2.80.070. My name is Grant Degginger. I am the ethics hearing officer for the city. And we, pursuant to the ordinance, Councilmember Shepherd has elected to have this hearing open. The public is here. However, there is no role for the public to play today. So please follow the instructions for muting your camera and your microphone so that we may not have any technical glitches that would prohibit the hearing proceeding in a timely manner. I want to start off today with just touching base on the record and some things that were submitted very recently so we can get the record squared away. Previously, I've received the complaint and the attached the documents that were attached to the complaint that were submitted by Mayor Larson. Mayor Larson is here today. Councilmember Shepherd is here today. I've received copies of several documents in redacted form. Those were the ones that are the subject of claims of attorney-client communication. Then I also received from Councilmember Shepherd on May 14th an email with a number of attachments and links in response to the complaint. And I've received from Mayor Larson a response to the pre-hearing submission by Councilmember Shepherd that came yesterday. And then I also received this morning, well, this afternoon, a response from Councilmember Shepherd. Are there any other documents or any other exhibits that people will be submitting?
I have a slide deck that I would like to share for my talking today.
Will you be submitting it as an exhibit, or is it just for the illustrative purpose of going through your, presenting your argument, if you will?
Is to present for my argument.
Okay, so you will not be submitting it as an exhibit for the hearing record, is that correct?
I guess I could later, but not yet. So
Okay,
it's in a PowerPoint format, and I'd like to turn it into a PDF. So
Mayor Larson, do you have any other exhibits?
I do not know. And if I could ask that Ms. Armstrong please turn off our video.
I did receive also a document from Mr. Sturbank today. Are there, my inclination is, although I've received a number of things rather late, is to allow all of them in as part of the record. Are there any objections?
I do. I object to the one that Mr. Sturbank submitted today because I haven't had a chance to review it. I'd like to have more time in order to respond to it.
Mr. Larson, what's your position on that document?
I suspect it's a document that Councilmember Shepherd had raised questions about whether it was included in the record. So that's basically addressing her concerns. She submitted an additional, I think, rebuttal about 20 minutes ago. I haven't had a chance to go through that, but I don't have any objections to that being included in the record. I don't know that there would be many new arguments introduced.
So, Councilmember Shepherd, your only objection to the document is that you haven't had a time to review or respond to it. Is that right?
Yes, correct.
So if I were to give you until Friday to submit a two-page response, would that be sufficient to resolve an objection?
That would be fine. Yeah.
Okay, I'll do that.
Okay.
But it's only on that one particular document, Councilmember Shepherd. It should not be on anything else.
Okay.
Is that understood?
Yes.
Thank you.
Mr. Deginger, could I, although I don't suspect I'll have a need to respond to the additional document that Councilmember Shepherd submitted 20 minutes ago, I would ask perhaps for the same consideration that if by Friday I have any additional information there, I would feel compelled to answer to. I'll keep it brief and maybe provide something by Friday.
That would be fine. Close the business Friday. So 5 p.m. Friday, would that be all right?
That would be more than sufficient. Thank you.
All right, we'll close it up at that point in time. Just trying to see if there's anything that we need to deal with ahead of time. Other than that, I believe that what I've set forth is that we were going to provide an hour to each party. Mayor, you will go first. You have the right to reserve some time if you'd like for a rebuttal. So out of your 1 hour, would you want to reserve some time to respond at the end?
Sure, although I'm satisfied that between my original complaint and the rebuttal to the brief that Councilmember Shepherd had submitted on June 15th, I provided last night a response to that, which could have been my verbal comments. I don't feel a necessity to read both the complaint or those response into the record or consume an hour of that. I'm satisfied that the ethics hearing officer has those documents, as does Councilmember Shepherd. And I don't feel I need to have to read all that into the record. So,
Okay. Very well. So you'll reserve some time. Do you want to know, do you want to pick a number of minutes that you wish to reserve at this point in time?
15, 20 minutes,
All right, let's say 20. Okay. And then before we get started, just to confirm that there will be no other witnesses other than you two speaking?
Correct.
correct. I indicated that the city attorney may be here, but Councilmember Shepherd seemed to be concerned that somehow the city attorney was acting on my behalf as a private attorney. That simply wasn't the case. He was there just to speak to any procedures and protocols and details or questions regarding exhibits and whatnot that have been part of the complaint. But in order to assuage her of any concerns of that, I indicated to him he didn't need to be here. However, if Councilmember Shepherd would like or the city attorney to join us for any questions she may have, I'm happy to have him on call and pull him into the meeting if required by either the ethics hearing officer or by Councilmember Shepherd.
Right. One last item under RCW, under Snoqualmie Municipal Code, section 2.80.070, it requires witnesses to be sworn in. And I understand that both of you will be maybe providing testimony, but also be providing argument. And because it will be difficult to ascertain where those are, I would ask that each of you be sworn in at this time. If you wouldn't mind raising your right hand. And is the testimony that you will be giving in this matter the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you very much. We'll begin with you, Mayor Larson. You may proceed.
All right, I'm just going to be very, very brief and summarize some content from both the original complaint and from some of my response that was submitted yesterday. As mayor, it is my responsibility to defend and uphold the integrity of our deliberative processes in order to best protect the resources entrusted to us by the residents and taxpayers of Snoqualmie. Consequently, it is my duty to submit the following formal ethics complaint against Councilmember Shepherd. This complaint asserts that Councilmember Shepherd has in multiple instances violated the Snoqualmie Code of Ethics, Chapter 2.80 of the Snoqualmie Municipal Code, the Code of Ethics for Municipal Officers, Chapter 42.23 of the Revised Code of Washington, and the Appearance of Fairness Doctrine, Chapter 42.36 of the Revised Code of Washington. These violations, which include misdemeanor criminal violations, are as follows. Participating as a decision maker in quasi-judicial proceedings that require impartiality while privately advocating an outcome. In violation of Snoqualmie Municipal Code 2.80.030, Section A1, in violation of Appearance of Fairness Doctrine in RCW 42.36, exposing the city to invalidation of a quasi-judicial decisions, the cost of reperforming the processes, and the cost of litigation, including potential damages, and in violation of either or both of RCW 42.36 and Snoqualmie Municipal Code 2.80.030, Section A1. And then also for improperly disclosing privileged and confidential information and legal advice in violation of Snoqualmie Municipal Code 2.80.030, Section D, and in violation of RCW 42.23.070, Section 4. Now, in my response to Councilmember Shepherd's brief, that the two principal arguments that she seemed to make are, one is in terms of participating as a decision maker in quasi-judicial proceedings, Councilmember's principal argument was that there's such a thing as neutral parties that she can communicate with during a quasi-judicial proceeding. There's no such language or allowance in the Revised Code of Washington that defines a neutral party. In fact, she has no authority to make that determination in terms of whether someone's neutral or not. There are folks that are pro, there are people that are against the project, and then there's a whole spectrum of people in between. And she doesn't have the ability nor the authority to determine if someone is somewhere on that spectrum. And in fact, she ignores in that RCW 42.36060 Section 2, which sort of captures people in that spectrum or what are so-called neutral agencies. It says this prohibition does not preclude a member of a decision-making body from seeking in a public hearing specific information or data from such parties relative to the decision if both the request and the results are part of the record. In other words, if she had a concern about a map, it wasn't, she had no authority to unilaterally go do research herself and reach out to some other county or department or agency. If she had questions, that should have been done during the deliberations on the record so that the applicant of the project had the benefit of looking at that same data or contacting that same agency to rebut or to answer those concerns. And when she was given 3 opportunities in the case of the maps with the King County GIS, there were 3 deliberations that took place after that date where she was seeking maps from a county official. And on 3 occasions, on the October 22nd, October 24th, and on the 29th, on the day the decision was made, she was asked prior to that if she had had any ex parte communications with anybody, and she said no, and did not put those communications on the record. As for the improperly disclosing confidential or privileged information, her primary response seems to be that that she is imbued with the authority to determine unilaterally if information provided by a city attorney is confidential or not. Again, she does not have the authority to make that determination on behalf of the city. The city is the client when it comes to attorney-client privileges. When a city attorney is providing advice to a city council or elected members, they should treat all of that advice and communications as privileged or confidential data. If there's any questions, that question should be brought directly to the city attorney, and if not satisfied, to the council, particularly usually in an executive session. And if not satisfied there, the council as a whole can make a determination on how to appeal to a third party, an MSRC or other impartial attorney, to perhaps make a determination on that. But she does not have the authority to, again, it's rather a dangerous sort of precedent or thinking that an individual council member or person could, take it upon themselves to make a determination of what would be considered confidential or not, or proprietary information. So anyway, with that to me is the kind of the high summary, the details and the evidence and emails and all the documents connected with those assertions are again contained in the original complaint. The response to Councilmember's brief on the 15th did not contain any new evidence or documentation, but simply just was more detailed in the response to some of her contentions. And I feel that record's complete. And with that, I'm conclude my comments.
Thank you, Mayor. I had a couple of just quick follow-up questions. With respect to the information related to this, I think it's called the Salish expansion matter, I think it was referred to in your submission. You said something about there being 3 occasions when there was an opportunity to disclose information by any of the council members prior to, in connection with that, the deliberations on that matter. Is that right?
That's correct. So what I try to do is assist you in actually finding that. You can see in the evidence there is the email or the email contacts that she had in communication she had with the individual from the GIS department at King County that took place, at least on one of the evidence was on October 10th. As we know, the decision on the Salish was made by the council on the 29th of October. So this is well before the decision is made. It's still under quasi-judicial proceedings. Those contacts were made their communications were made on the 10th. The next meeting that was held was on October 22nd. And I actually used the links or exhibits that Councilmember Shepherd provided you in her brief. She provided you links to the YouTube videos of those deliberations or council meetings. She put a timestamp. However, it would take you a while to wade through that because the timestamp starts at the beginning of the meeting. I modified those and sent you links in my response that changed the timestamp to the moment when the city attorney asks the council, have you had any ex parte communications? And where a council member says no. And those deliberations were again on 3 occasions, on October 22nd, on October 24th, and October 29th, on the night the decision was made. And in each instance, it shouldn't take you more than 1 or 2 minutes to look at those links with the timestamps to go directly to when she said, on each of those occasions, have you had any communications? And her answer was no. And she never put those communications on the record.
Okay, and then I'm also just trying to make sure I understand the chronology as well. And that is,
Now, the other argument that becomes a little is that it seems clear that Councilmember Shepherd was intending to appeal to the council to reconsider that decision, and so she had, again, subsequent communications outside of the record, outside of the process, that again I feel violated appearance of fairness, and so the argument would be that had that been brought back and reconsidered, then in her mind that decision hadn't been fully baked and made, and so. So for an abundance of caution, she should have still abided by the appearance of fairness and quasi-judicial requirements, knowing that she would try to have that decision reconsidered.
okay, so there was a reconsideration request made at a subsequent council meeting. Is that what you're saying?
Well, it didn't quite get there, Councilmember Lissay. I encourage you to. Well, I would be happy to provide a link to that YouTube meeting when the council meeting when Councilmember Shepherd brought up the issue again, proposing to relitigate it or reconsider it, and she characterized that Councilmember Lissay shouted her down. I take issue with that. I think he respectfully raised the concern that it was inappropriate to reconsider, and I sustained his objection. But you can see that the behavior on that. I'd be happy to provide a link to that particular council meeting when she brought the matter up again, but it was objected to by one of the council members, and I sustained that. And the council did not second her request to bring that back as a motion on the table. So
No need for any additional. I just wanted to confirm the chronology.
Yeah.
Let me just see if I had any other questions from your submission or your presentation. I think that will do it for now. So you used about 15 minutes of your time, Mayor Larson.
yeah, thank you.
Councilmember Shepherd?
Yes, how can I share my screen?
Yeah, that will be something that I think either the mayor or staff might be able to provide help with.
Councilmember Shepherd, in the bottom center of the screen, if you scroll your mouse down there, the menu should pop up, the Zoom menu should pop up, and you should see a green share screen button. If you just scroll down there and hit that share screen button, there you go.
Okay, so you see the first slide in this?
Yes, we can see it.
Okay. All right, so I'm going through the complaints as in the order that they appear from the original complaint from February of 2021. And the comment or statement here is Mr. Larson's allegation regarding the Salish expansion. And it says that I engaged in multiple ex-parte communications with King County, staff and the King County Boundary Review Board.
Someone could please mute Ms. Lux, or if anybody who's not a participant, if you could please. Ms. Lux, could you please mute your microphone? Councilmember Shepherd, I'm sorry, you please.
Okay, so again, the King County staff, King County Boundary Review Board, the Washington Office of Financial Management regarding the matter, including obtaining documents outside the record in violation of the requirement to consider only official record and without disclosure so that opposing party could rebut. Disclosure requested of all council members by city attorney at city council meeting on 10/29, which was the last meeting regarding this issue. No disclosure was made of these contacts, and then he refers to King County GIS Department and King County Boundary Review Board and Office of Financial Management. In regarding to the statement that as far as appearance of fairness, there's no concept of neutral. If there was no concept of neutral, why would they state opposing are proponent and opponent, and also in the MRSC book regarding appearance of fairness, there is they do describe neutral parties. So it is a concept in the appearance of fairness. And then, so in Mr. Larson's complaint, he says that it was pending through November 13th, 2018. So my response is pending for city council ended on October 29th. And the RCW 4236060 during the pendency of any quasi-judicial proceeding. My Exhibit U, Resolution 1461, adopting findings of fact, conclusions of law, and conditions proving the Salish Lodge and spa expansion. The document was signed on October 29th of 2018. Mr. Larson's complaint, ex parte communications. In order to be ex parte communications, the communications must be during the pendency of the quasi-judicial proceeding and with a proponent or opponent, and with respect to the proposal, which is the subject of the proceeding. RCW 36060, ex parte communications with opponents or proponents with respect to the proposal, which is the subject of the proceeding. I have contacted some of these agencies and I asked them, do they perceive themselves to be proponents or opponents? And they do not feel that. Okay, so Mr. Larson's complaint continues. Inquiries with King County staff. This is the subset that I'm addressing, having to do with the different agencies. So my response to all of these contacts that he does have documents to support. They are King County staff, King County Boundary Review Board, and Office of Financial Management. And the dates are 10/10, which is during pendency, and 11/9, which is after pendency, and 11/2, which is after pendency. Is it an ex parte violation? No, because they're neutral. The second one is no, because they're neutral and after pending. And the third one, is it ex parte violation? No, because they are neutral and it's after pending. Mr. Larson's complaint, disclosure requested of all council members by city attorney at city council meetings on 10/29. No disclosure was made of these contacts. At each of the quasi-judicial meetings for the Salish matter, Mr. Sturbank polled each council member if they had any ex parte communication with proponents or opponents. No such poll was conducted on November 13, 2018, because the matter was no longer pending. And then here's a list of all of the meetings that were the quasi-judicial meetings that we used to make that decision for the Salish expansion.
Councilmember Shepherd, quick question for you. Just is November 13th the date when there was this motion for reconsideration?
There was no motion for reconsideration. That is a lie.
So what happened? What did anything happen on November 13th of 2018 relevant to the Salish?
There were people who showed up and they wanted to talk about it during a portion of the meeting where you can talk about items that are not on the agenda, which they did. And then long after they talked about it, I raised my hand to speak to them, but I never made a motion. And I do have the video later in these my slides.
Okay, thank you very much.
Okay, so going on through the complaint, council member engaged in multiple ex parte email conversations and one or more meetings at her home with opponents of the matter, including planning and directing city council testimony and submission of documents by project opponents, and then in support of her attempt to have the city council consider and reverse the quasi-judicial decision the council had already made in violation of the requirements to remain impartial and to consider only the official record. So here, there, 11/9 is after the pendency, 11/2 is after pendency. So is 11.9 again, and 11.8 and 10.29. There were no documents dated 10.29. So I'm not sure what's referred there is being referred to there. But all of these dates are all after 10.29, which was the end of the pendency period. Okay, so Mr. Larson's complaint contains these dates, 11.9, 11.2, other specified dates prior to 11.9 and meetings on 11.8 and occurring between 10.29 and 11.13. So my response is supporting documents of 11.9 and 11.2 are discussed previously in my previous slide. Other specified dates prior to 11.9 is not evidence. We don't know what he's referring to. All the dates are after pendency except for 10.29. However, none of the supporting documents are dated 10.29. So we have one item, meetings occurring between 10.29 and 11.13. Now this is, even though this is outside of pendency, I wanted to try to find what documents are being referred to. And the only document that appears to fit this description is a document named Pleading Stores Petition to File Amended Complaint 11019, paragraphs 7 to 10 regarding meeting on 11.8, all after pendency. This document refers to the quasi-judicial hearing and describes my decision inaccurately. It also says that I was going to make a motion on 11.13, which I had no intention of doing and didn't happen. So here I have the video and I wanted to play that for you quickly. It's very short.
As small towners, we've always had a heart for the heartland.
Sorry about
While
the
we're excited to join
ads.
T-Mobile.
Commercial too.
Yes, sorry.
Councilmember Shepherd.
So back to the Salish expansion and the fact that the one parcel or the combination of parcels was about 100 acres. And the representation was.
Mr. Mayor, point of order. Yeah, I'm sustained. This is not an item on the agenda. It's not on the agenda, although I've been.
Okay, so that's what was said. I did not make a motion and we don't know what I was intending to say. And so this is where there's speculation going on. So if that video shows that I did not make a motion on 11.13. However, if there's some, the problem is some of these statements or complaints are not clearly tied to which document is being referred to. But so I did my best to try to align it. And that's the closest I could come. So then regarding the events of the 11.13 or November 13 council meeting, Mr. Larson was at the meeting and heard what I said and did not say. His complaint provides no rationale for why he states the pendency went until November 13, when it actually ended on October 29. It appears he is complaining about what he thinks I was intending to do.
Quick question on the stores matter, because I noticed that you had submitted that with your submission, Councilmember Shepherd. Just want to get a sense of, for what purpose did you submit that document?
I don't remember, to be honest. It was in his among his documents, and I don't know why I submitted it for mine. I don't remember what my thought was. To be honest, I was trying to put together a list of exhibits with not enough time for me. You know, I'm not familiar with this process. So.
Okay, that's fine. That's fine. Go ahead and continue your presentation.
So Mr. Larson's complaint, violation of the requirements to consider only the official record. As established previously, there was no attempt to reverse the quasi-judicial decision the council had already made after October 29. Thus, any evidence after October 29 about considering information outside the official record is irrelevant. Response regarding email of October 10 in the Salish expansion record, of written legal description of the land area in use, of land area in question, was provided in the official record. Similar to looking up an unfamiliar word in the dictionary, I reached out to a neutral party to get a map based on this legal description. That was the subject of the October 10, 2018 email to King County that Mr. Larson cites. The map provided in response to October 10, 2018 email did not change my review of the project or affect my decision. A map based on the legal descriptions of the property was not new information outside of the record. It was my attempt to better understand the information in the record. It never occurred to me that getting a map would be outside the record. So the next part of his complaint, mill site matter pending 317 to current. So now we're into another matter. Council member engaged in multiple communications with inquiries regarding move this a bit. Regarding the matter in contradiction to the requirement to remain impartial, consider only the official record and avoid prejudgment of issues without recusing herself. It refers to the Washington Department of Ecology in December of 2018 and April through May of 2020. And then one communication with the Snoqualmie Watershed Forum. Okay. So Larson's complaint engaged in multiple communications with and inquiries regarding the matter in contradiction to the requirement to remain impartial, consider only the official record and avoid prejudgment of issues without recusing herself. Response, decision makers can accept correspondence from anyone, provided the correspondence is disclosed and made part of the record of the quasi-judicial proceeding. Quasi-judicial proceedings have not started yet. Exhibit K, the appearance of fairness doctrine in Washington State, published by the Municipal Research and Services Center, MRSC, page 22. Does the appearance of fairness doctrine prohibit a decision maker from reviewing or considering written correspondence regarding matters to be decided in a quasi-judicial proceeding? No, decision makers can accept written correspondence from anyone, provided the correspondence is disclosed and made part of the record of the quasi-judicial proceeding, RCW 42.36.060. So we have not started our proceedings, so it is too early to disclose anything. So that doesn't hold water. Okay, going on in his complaint. Council member Shepherd gathered and prepared documents summarizing information regarding the quasi-judicial mill site application, which is not part of the official record, contravening the requirement to consider only the official record when deciding such matters. Email to the Washington Department of Ecology on 5/13/20. Council member Shepherd engaged in multiple lengthy email conversations with opponents of the matter and Washington Department of Ecology staff in violation of the requirement to remain impartial, December 28, 2018. So, gathered and prepared documents summarizing the information regarding the quasi-judicial mill site application, which is not part of the official record, contravening the requirement to consider only the official record when deciding such matters. Email to Washington Department of Ecology on 5/13/20, engaged in multiple lengthy email conversations with opponents of the matter and Washington Department of Ecology staff in violation of the requirement to remain impartial. Response, the official record has not been finalized, and all documents that I have communicated about regarding the mill site have been submitted to become a part of the record through the draft environmental impact statement process. These email messages can be disclosed and made part of the record when we have our first quasi-judicial meeting on the matter, RCW 42.36.060.
When did you make that submission of the information you received from Ecology?
It was during I don't remember the exact dates. I would have to go look that up.
Can you tell me approximately when? Was it after this complaint was submitted?
No, it was before the complaint was submitted.
Okay. And can you explain, could you have asked staff to get this information?
Actually, with the dynamics we have at the city, when I ask for something, it's rarely responded to. So no, I couldn't have asked staff.
And I take it in this case, you did not ask staff. Is that right?
Right.
Thank you. Keep going.
Okay, so now we're into the confidential stuff, improperly disclosing privileged and confidential information and legal advice, items 4 to 6. Improperly disclosing privileged and confidential information and legal advice. Council members are prohibited from disclosing confidential information gained by reason of their position. RCW 42.23.0704 SMC 2.80.030D. Legal issues. Council member Shepherd provided multiple attorney-client privileged documents summarizing and analyzing city legal issues and exposures to one or more individuals not entitled to the documents. 7/19/19 email forwarding to privileged documents dated 7/17/19. Electioneering matter. Council member Shepherd provided an attorney-client privileged document summarizing a legal issue to one or more individuals not entitled to the document, October 11, 2019. Mill site matter. Council member Shepherd provided a confidential document from the Snoqualmie Watershed Forum director regarding forum members' consideration of the forum position on the mill site to an opponent of the proposed project. So going back to each of these issues, Mr. Larson's complaint provided multiple attorney-client privilege documents summarizing and analyzing city legal issues and exposures to one or more individuals not entitled to the documents. 7/19/19 email forwarding to privileged documents dated 7/17/19. Response. As evidence, one email dated 7/19 is cited, which I understand was redacted before providing it to the hearing examiner. I want to go back to the previous slide and also look at display my notes for this slide. Sorry.
Okay, take a minute. Take your time.
Okay. Okay, so in February 2021, when the initial complaint was sent to me, the supposedly privileged and confidential emails were not provided, but were noted as provided upon request. On February 9, 2021, I sent an email to Mr. Larson, Mr. Sturbank, which I included a request for those 3 emails. They never responded to my email. Therefore, I needed to rely upon copies of those emails in my city maintained email. Mr. Larson's description of those email messages does not match what I find in my city maintained email. The content of the supposedly privileged email is only publicly available information, which is excluded from privilege. Mr. Larson's allegation of my committing a further violation of attorney-client privilege by discussing the contents of the privileged communication is false. I only talked about the categories of content of the supposedly privileged communication, just as the complaint categories about the confidential email. So going back to home view. Okay. So going back to one of the first emails. And so this was 7/19. So as evidence, one email dated 7/19 is cited, which I understand was redacted before providing it to the hearing examiner. Mr. Larson says this email forwards 2 privileged documents dated 7/17. However, the 7/19 email has no attached documents. The cited email thread began on 7/16 and continued through 7/19. Mr. Larson claims that there are privileged documents dated 7/17 in the cited email thread. The portion of the email thread that happened on 7/17 contains email discussions among many city staff members, the city council, Mr. Sturbank, and the mayor. None of those 7/17 emails are marked confidential or privileged, including the 2 emails that Mr. Sturbank sent to the thread on that day. So provided multiple attorney-client privilege documents summarizing and analyzing city legal issues and exposures to one or more individuals not entitled to the document 7/19 email forwarding 2 privileged documents dated 7/17. Mr. Sturbank's email dated 7/19/1248 in the email submitted in the redacted form by Mr. Larson adds the text attorney-client privilege and confidential to the subject line that was used in the earlier emails in the thread. However, I assert that the content of this email does not warrant such designation. Most of Mr. Sturbank's 7/19 email merely describes the process that the city had been using for the processing of the type of refunds in question and makes reference to a city ordinance and a section of city code. I do not see anything in that email that is advice from attorney to client. This advice contradicted what the state auditor's office found in their audit, provided as my Exhibit E, which states a state auditor office findings. Okay.
Just so I'm clear on this, Councilmember Shepherd, are you saying that you forwarded, do I have that right, that you forwarded the email string that included Mr. Sturbank's email, internal email to this, to the state auditor's office?
I talked to them about it. I don't recall if I forwarded it to them, but I had been talking to them extensively about the problem we were having with refunds in the city. So I would have to have more time for discovery, but I know that they are aware of what the city attorney had talked about.
Well, I believe in one of your submissions, you said that you had forwarded it.
I forwarded it to other people because I felt that it was something that our residents needed to know about.
But I also believe it's in your response to the allegations that you sent on May 14th, I believe you also said that you had forwarded the email that that email string, which included Mr. Sturbank's email, internal email to staff to the state auditor's office. Is that right?
I think I did. I don't recall it precisely, but I believe I did.
Did you speak to Mr. Sturbank before you did that?
No.
Okay. Okay.
I spoke to Mr. Sturbank before he sent his email, and I was alarmed at Mr. Sturbank's response. And he was basically saying that this is the correct thing that we're doing, which obviously was wrong. After getting the response back long after the auditor had done an audit. But I had provided a lot of information prior to his response that he should not have told staff what he told them. It was incorrect. And it would have caused staff to basically potentially break laws. So that's what I did. So that's that.
Thank you.
Uh-huh. Okay. And let's see, had been the type of questions in this residence ordinance. Okay. Which states SAO findings. Okay. Due to financial and records procedures that appeared to be contrary. Move this over so I can't see the entire statement. Sorry. Due to the financial and records procedures that appear to be contrary to city or state regulations, I contacted the state auditor. I'd actually been in touch with them prior to that, but anyway, the state auditor issued the following. Concern: the city did not follow record retention requirements for refunds made during 2018 and 2019. The refunds for the deposits are more than 6 years old, but the supporting documentation has been destroyed prior to the refunds were made, since they have exceeded the record retention period. Result: we reviewed the Washington State Local Government Records Retention Schedule for contracts and agreements and determined that the city must keep the original documents for 6 years after the completion of transaction, or 6 years after termination expiration of instrument of coverage. After that time, the records can be destroyed. Our audit found, the city did not keep the original documents to support the refunds issued during our audit period. We tested 20 of the 65 refunds in question, totaling $53,349, and found that 19 refunds received from 1998 to 2016 were not properly supported with the original records. We communicated this item in a recommendation to the city during our exit conference held March 3rd, 2020. Okay, email from the state auditor's office is Exhibit D, MOUs refunds, and Exhibit E, hotline letter, citizen H19096. WAC 44-14-03-005 states that the unlawful destruction of public records can be a crime. RCW 2140.16.010 and 40.16.020. RCW 4309-185 on reporting illegal activity to the state auditor's office states, state agencies and local governments shall immediately report to the state auditor's office known or suspected loss of public funds or assets or other illegal activity. As a government employee, I am required to report suspected illegal activity by law. Okay, so Mr. Larson's complaint about the electioneering matter provided an attorney-client privilege document summarizing a city legal issue to one or more individuals not entitled to the document. My response: Mr. Larson's complaint alleges I provided an attorney-client privilege document to one or more individuals not entitled to the document. As evidence, Mr. Larson cites one email dated 10/11/19, which I understand was redacted before providing it to the hearing examiner. In the cited email, I forwarded an email to my husband, Richard Dick Scheel. The email that I forwarded was sent by Mr. Sturbank on 10/10/19 to the city council, the mayor, the city administrator, and the head of city's HR department. Mr. Sturbank's email included attorney-client privileged and confidential in the subject line. However, I assert the content of this email does not warrant such designation. The email consists of quotes of public documents, RCW guidelines from the Washington Public Disclosure Commission and the Snoqualmie personnel policy, and descriptions of events that happened at a public meeting attended by many members of the community. None of these items in Mr. Sturbank's email are privileged or confidential. They are all public information. I felt that
Councilmember Shepherd, I just want to caution you, if there's information that includes legal advice in that document, I've received it in a redacted form. My understanding is that the privilege has not been waived by the city. So if you can, you've generally described the subject matter, but I just want to caution you about not disclosing any advice.
okay.
All right.
All right, so none of these items in Mr. Sturbank's email are privileged or confidential. They are all public information. I felt that it was important to show Mr. Sturbank's email to my husband because of the possible severe cost to our shared marital finances if the alleged violation was substantiated. Note, the Washington Public Disclosure Commission later ruled that there was no violation. And here's a link to that. I will let you look at that link later. It's very lengthy, but there was, and this is not part of the confidential email, but it relates to the confidential email, and it was same subject area, same topic. So anyway, now the mill site matter. This is the email regarding the mill site matter. Ironically, this email was actually provided with the documents that came with the complaint. So for this to be considered confidential when it was actually brought along with the complaint, while two others were not, I'm not sure what the distinction was between one confidential document and two others. So anyway, Mr. Larson's complaint alleges I provided a confidential document to an opponent of the proposed project. Mr. Larson cited as evidence an email from the Snoqualmie Watershed Forum dated 6/26/20. This may have been redacted before providing it to the hearing officer. The document list submitted with Mr. Larson's complaint mentions two Watershed Forum documents with that date, one of which he describes as confidential. He does not adequately identify which document he is citing, but I assume from the context, he intends to cite the one he describes as confidential. The message was sent to over a dozen Watershed Forum members who are public office holders, making it a public record. Nothing in the email submitted by Mr. Larson has any indication of being confidential. And then here's a list of all of the documents that were submitted along with Mr. Larson's complaint. There's only one that appears to not be, the name of the file doesn't match the content of the file. It's named 12/28/2018 Snoqualmie Watershed, Snoqualmie Warehouse or Mill Site, but it's actually May 13, 2020, and it's Warehouse or Mill Site, and it's a duplicate of another one that's here. So it's nothing substantive, just doing that. So Mr. Larson's complaint begins with these high-minded words: as mayor, it is my responsibility to defend and uphold the integrity of our deliberative processes. Every one of the allegations in Mr. Larson's complaint are now over a year old. Most of them date back to 2018, which causes us to wonder, why did it take almost 3 years for Mr. Larson to discover his responsibility? Does it seem reasonable that the mayor would wait for years to file a complaint? Does it seem like only a coincidence that he chose to do so during an election year? Mr. Larson's complaint purports to be based on Chapter 2.80 of the Snoqualmie Municipal Code. When we open the chapter, we read, the chapter shall not be construed so as to impair the ability of city officers and employees to participate in ceremonial, representational, or informational functions in the pursuit of their official duties. Most of the allegations challenge my right to perform my official duties of gathering information and informing public agencies and the public about that information. Again, quoting from Section 2.80. No city officer or employee while holding such office or employment or at any time after leaving office or employment shall disclose or use any confidential or privileged information gained by reason of his or her official position for a purpose which is for other than a city purpose, provided that nothing shall prohibit the disclosure or use of information which is a matter of public knowledge or which is available to the public on request. All of my actions were for a city purpose. Further, all of the information that I provided to public agencies and the public were provided with the understanding that the information was subject to public disclosure. And what were those actions that I took? I gave information to the state auditor whose office verified information and directed a corrective letter to the city. I gave information to the Department of Ecology to correct omissions and ensure that agency had accurate information about city projects. I met with citizens over a quasi-judicial matter that was closed. I shared public records and interested constituents. I sought a map to match a publicly available legal description of a property so that I could understand that legal description. I have presented a detailed and factual response to each and every one of Mr. Larson's allegations. I have documented that Mr. Larson's complaint is unsupported by evidence and misapplies laws. By borrowing from Greta Thunberg, this is all wrong. In the city of Snoqualmie, the mayor and the council are two branches of government. It is all wrong for the head of the executive branch to seek to restrict and harass an elected member of the legislative branch with baseless accusations that are years old. It is all wrong for the executive branch to abuse the instruments of power to support baseless accusations that are years old. Mr. Larson states, as mayor, it is my responsibility to defend and uphold the integrity of our deliberative processes. Like the complainant against me, Mr. Larson is all wrong. The council is responsible for its own deliberative process. The mayor has no right to police or obstruct the council or its members. And make no mistake about it, Mr. Larson has for years exhibited a pattern of obstruction affecting my authority and duty to function as a council member. If Mr. Larson's complaint is approved, what will the effect on the public and on existing and future officials? Will administrative processes be better if elected officials must worry about an ethics complaint for talking to neutral parties, seeking information and sharing information? What of reporting suspected irregularities to the auditor or to the PDC? Open government laws require that the public's information is open to the public unless specifically regulated. But if a misdemeanor charge is threatened, how will elected officials behave when asked by the mayor or other official to improperly keep politically embarrassing information or evidence of illegality confidential? Will elected officials go to a public watchdog agency with their concerns? Will they seek a second legal opinion? Or will a bad decision in these proceedings set a precedent that will forever inhibit present and future council members? These are not idle speculations. These very proceedings contain evidence that Mr. Larson may have attempted to withhold information from public agencies regarding the destruction of public documents, possible police malfeasance, and improper financial accounting. It is time to bring an end to Mr. Larson's pattern of obstruction and harassment. Mr. Larson's complaint should be dismissed because it is unsupported by the evidence and misapplies law. But it should also be dismissed with prejudice because Mr. Larson's complaint should not be allowed to have a chilling effect on the right of the city council and its members to hold the executive branch accountable. Mr. Larson's complaint should not be allowed to vindicate a pattern of obstructing council efforts to communicate with public agencies in either gathering or sharing information. Mr. Larson's complaint should not be allowed to abuse the city's ethics process for political purposes. Mr. Larson's complaint should not be allowed to game our political process by withholding objections that could have been timely expressed by him and addressed by me years ago. Mr. Larson's complaint should not be allowed to confer confidential status on materials that belong to public sphere and should be accessible to the public. Mr. Larson's complaint should not be allowed to defend administrative practices that at best are incompetent or manipulative and at worst are illegal. There is more to stake here than my own reputation, innocence, even freedom. The future of our city's governance and the rights of the public to the open democratic government that they have elected is on the line. That's it.
Okay, thank you for your presentation, Councilmember Shepherd. I had a couple of follow-up questions, if I could. And I'll try to take it from the start of your presentation moving forward, if that's helpful. So I'm going to start with the Salish matter. Just so that I'm clear, the information that you obtained from King County, this map, Did you ever submit it for the record?
It was on the record.
You're saying that this map was already in the record?
It was added to the, let's see. So it was on the record on October 22nd. And it did not happen right at the beginning of the meeting. It happened somewhere in the middle. And I can send that link to you with that timestamp. It's a very interesting discussion about maps for that project.
Did you identify that this was a map that you had obtained from King County?
Correct.
outside? Okay, and was it in response to the request by the city attorney for any, for identification of any ex parte communications?
It was discussed by council, and so there was no conversation around, it was basically put in the parking lot when we started to discuss it. There was a beginning of discussion. The proponents and opponents were there, and it was put in the parking lot, but it was definitely disclosed.
Okay, and prior to the council vote on the resolution, which I believe was on October 29th, did you meet with any of the opponents to the annexation?
No,
Other than the boundary review board staff, the county GIS staff, did you confer with anybody else about, or seek information from anybody else about the expansion in the?
actually, the boundary review board had more to do with our history of annexation. And that was all after October 29th.
Okay. You understood that the matter that was voted on October 29th was a quasi judicial matter, right?
Yes,
And you understand that that's different than a legislative hearing, correct?
correct.
And the reason is in part because the applicant has also has some rights as well, correct?
I'm sorry, I'm not following what you're saying.
Well, the applicant also wants to, it needs to be ensured the right to be sure that all the information that is being considered by council is public as well, correct?
Yes.
Okay. Moving over to the next matter, which was the one involving the mill site. I was curious for what reason did you contact the Department of Ecology staff?
It had to do with, I found out that their repository of documents, there had been, there was a mill that operated there for over 100 years, or about 100 years, I'm over, but approximately 100 years. And the records and the State Department of Ecology had, I think, gone through some probably big changes with their enterprise system, and some of their files where the links were not quite right. And I happened to cross it when I was doing the Shoreline Master Program, looking at Horst Lake. And there was a blog for fishermen. And one commenter said something about they found this document in the Department of Ecology, and I was curious what that link was, and it was broken. So I realized that the link was, there was something weird about it, and that's when I started talking to the Department of Ecology about that particular file, which was not having to do with the mill site. The original mill site is different than the area that's being developed. The larger original mill site, the proposal to develop it is a subset of the original mill site. So this is really more to do with that document having a link that was not properly configured to work with their indexing. So that's really what I was doing, was I was trying to peel back the layers of the onion on why that link wasn't surfacing for where it should, in relationship to Snoqualmie. And so then they found out that they had a problem with that file, and there were similar files like that. And that was long before the draft environmental impact study was closed. And so anything that was discovered at that time was all submitted to the city for that. So everything should be there. I didn't really read those documents. I was just, searching for one thing that had to do with another area, and found that it was, the link was constructed oddly. I think that's probably the easiest way for me to describe that.
Do you have an understanding of whether the Department of Ecology has any regulatory role with respect to development at that mill site?
I think that they are supposed to, but I think they're underfunded. And so they probably are not going to do much in the way of enforcement. So I don't know. I think really what I was thinking is that all the information that we can gather about what's going on in that area is important for us to know. And that's as far as my thinking took that, and for it to be processed along with all the documents that are being gone through by the development for the mill site. I want to make sure that that's all incorporated. And they are scientists that are looking at this. I'm not a scientist. I am just looking to make sure that all of and this is from my understanding of talking to the Department of Ecology, is that they look at historical documents to figure out what to do next. And so it's important for them to have all of those historical documents. If you can't find them, then then that's a problem.
Did you ever ask, before contacting Ecology, I might have asked this, did you confer with city staff to see if the information that you had and wanted to share was something that staff needed to have?
I'm not sure why we're asking that question, because it's not a requirement. Why would I have to?
I'm just asking if you did it or not. And if you
I did not. No, staff has not been easy to work with. So no. I can't get some fundamental questions answered. So no. But I did everything that has been produced has been sent to staff. They've gotten everything.
Okay. Have you taken a public position with respect to the proposal itself?
No.
Okay, moving on to the confidential privileged information. I think you had said that you, with respect to this, what was called the electioneering matter, the email dated 10/11/19. I believe you said that it was marked as attorney-client communication. Is that right?
Correct.
And that you shared that communication with your husband, right?
Right.
Okay. With respect to the communications from July of 2019, you seem to suggest there's some confusion about exactly which documents there are here.
Right.
So I'd like some help maybe getting that straightened out. If it's possible, I would like to get have, I'm asking this of the parties. I want to make sure that I have the redacted, and I only mean the redacted version of it. For some reason, I can't seem to find it in my list of documents. I got 2 copies of the October 11th document, and for some reason, the redacted version of this document is missing from my set. So I want to make sure I have it in the record. And so I'm going to make a request to the city to provide and circulate it to, if we can circulate it to Councilmember Shepherd and Mayor Larson at the same time, just to make sure that everybody is looking at the same piece of paper.
Yeah, that would
be helpful.
be great if we could make the request. Yeah.
Okay,
Yes,
thank you.
are we doing that for all of the listed complaints, confidential emails? Because we didn't get anything from the city on that.
So did you receive a redacted version of the October 11th, 2019 document?
No.
Okay. All right, let's make sure we do that and get them in redacted form. Just want to make sure everybody has
Yeah,
them.
it's all 3, just all 3 of the emails that are listed.
All right. Before you shared the electioneering document with your husband, did you ask the city attorney if that was appropriate to do?
No.
Now I want to move on and ask some questions about the watershed forum document. What, if I understood your testimony correctly, this is a document to describe the forum's comments to the mill site project, is that right?
Yes.
And prior to that document being shared, is there a process that the city has for taking a position?
I don't know. The document that we're talking about is included in the complaints list of unrestricted, if you will, or unredacted documents.
That's the August of 2020 document.
Okay.
Is that right?
I'm looking at my list here.
No, it's June 26, 2020, excuse me. Is that right?
I'm just reading, sorry, but
Fine.
yeah, it was the DEIS, yes. So that would be, and there's 2 files that comprise the 1 email. I don't know what they would redact, and as part of, they've submitted this with their public records. So.
And it's your position that the document wasn't confidential at the time it was sent out. Is that right?
Right. It's not.
Was it a draft or was it a final document that had been approved by the forum?
It's a draft. But it was being discussed in public.
So you provided a draft of the document to a constituent, is that right?
Correct. It was not from an attorney. It was
was it
public.
prepared?
Huh?
Was the draft prepared by the forum or by you, just so I can better understand how
By the forum.
Had it been, is there a process for approval of final drafts that the forum has?
I wouldn't know.
Okay,
I think they all get in the room and they just say, anybody got a problem with it? And somebody might say something and then they'll probably change it.
is there a practice that the council has about signing on to um, recommendations or statements of regional organizations that it has membership in?
I'm not familiar with that. It may exist, but I am not aware of it.
Okay, thank you very much, Councilmember Shepherd. Mayor Larson, do you want to take a few minutes for your rebuttal?
Yes, thank you. Just a few items. It shouldn't take 20 minutes. I would draw attention to Mr. Deginger to the stores document. You know, again, I'm going to try and go back in the order of our PowerPoint presentation. The stores document, I think, reveals a great deal. There's a pattern of behavior that we've seen from Councilmember Shepherd in terms of her involvement with, political allies of hers or anti-growth, that we could only speculate about, but it's rather remarkable in the stores document that Ms. Jane Storrs lays out in quite detail some of the activities of that group in the beginning of that document. Now, she says that's lies and misinformation, so it's up to you to decide who's telling the truth, but we think that is a compelling story to be told there. As far as the mill site on the watershed forum document, you know, we weren't even aware that the watershed was deliberating on some sort of a statement on the mill site. Councilmember Shepherd was assigned as the liaison to the watershed forum, and of course the role of the liaison is to provide a two-way communication, to communicate pertinent information back to the city council, or to report on that, anything that is of relevance or that the council needs to hear. And on a couple of cases, you know, she did not do that, or she didn't do that on this one. So I don't recall ever having any report on these activities of the watershed forum regarding the mill site. And even if there had been a report, the reaction of the council would have been, we don't want to hear about it because that's going to be a quasi-judicial matter, so we shouldn't be involving ourselves with that. If you look at the email itself, in fact, let me throw it up real quick, if I can find where I put it. Sorry, bear with me for one moment. Oh, well, for some reason, it's not showing me when I do a share screen, the email. Let me just read a couple of sections. You all have the document. You know, it's basically soliciting from the watershed forum and staff, which, by the way, this is still in a deliberative process, so therefore it's confidential from them, asking for any input on this sort of position document on the mill site, or basically, dear Snoqualmie Watershed Forum staff, the city of Snoqualmie has requested we provide comments on the recently published Snoqualmie Mill Plan Commercial Industrial. Now, this was notice put out to all of the community, so we didn't specifically go to the watershed saying provide comments. It's just notice for the DEIS is out there. Does anybody want to comment on it? And so they were reacting to that public notice. We are requesting your review and comments by Tuesday, July 7th. Comments are due to the city of Snoqualmie by July 10th. Then it says, if you have any questions or comments about this letter, please direct them to me or Corey by Tuesday, July 7th. If we do not hear from you, we will assume you approve sending the comment letter. We will be requesting signatures from and so forth. But anyway, that's pertinent. I mean, any council member that usually would have been that liaison role would have immediately said, I must recuse myself from this conversation, given that I'm a decision maker in an upcoming quasi-judicial process. I don't want my name attached to any sort of comments from this watershed forum. And to your point about the processes, council members, if they're going to a liaison to SCA, of course, if there's an issue they want to vote on, we'll often come back and touch base with the council members to see what the majority's position is. There was an issue that came up on the North Bend's water comprehensive plan where I got an angry
Objection.
What's your objection, Councilmember?
We're just getting off topic.
I think my question was there a process? And I think Mayor is responding to that in his rebuttal. I think it's appropriate. I'll overrule the objection.
Yeah, so there was got an angry phone call from the mayor saying, why has Snoqualmie opposed our water comprehensive plan? And I didn't know what he was talking about. Unbeknownst to us, we came to find out that Councilmember Shepherd is the liaison and represented to the watershed forum that Snoqualmie opposed the watershed plan because she opposes growth in North Bend or growth anywhere. And subsequent to that, the council stripped her, or the mayor pro tem stripped her of that liaison role to the watershed forum. And I believe the council censored it in part due to that. It's indicative of sort of the behavior of acting unilaterally or separate from checking in with, majority of the council to make sure she has the full support of the council prior to stating that she speaks on behalf of the city. The bottom line in the open public records or appearance of fairness doctrine is that a decision maker must remain impartial, so you can't endeavor in things. Councilmember Shepherd has made strong points about that a councilmember or others shouldn't be prevented from seeking information, or that, here's the fundamental distinction or principle in this. Always in land use decisions, even ones that are quasi-judicial, there will be stakeholders and members of the public that will approach that council member and start talking about the issue, or they will email them documents. And so that's out of a council member's or decision maker's control. And the way you cure that is those are ex parte communications, and you're basically a passive recipient of information. What is fundamentally different, what you are not allowed to do, is to be an active seeker of information. Councilmember Shepherd made the statement, "I'm not a scientist." She's not. Nor is she a lawyer, nor is she a geologist, nor is she a biologist. And I could go on with all the expertise of individuals that take place on doing research on the history or the geology of a particular site, such as the mill site. And for her to endeavor to do her own comprehensive research outside of the record or outside of the process, even before, it's going to be quasi-judicial, can risk having the product of that research could be she starts to formulate an opinion and a position on that project that is, violating the right of the applicant to know what's influencing her decision. And this is precisely why any of her research or questions around that have to be on the record in the public hearing, and she must patiently wait for that so she can bring those questions before the decision-making body at the time that this decision is making forward. A decision maker is absolutely not free to be, doing their own research in conjunction to that. In regards to the disclosure of information, she made comments about, the audit issues, and absolutely a council member should be free to do their due diligence on questioning any fraudulent or corrupt behavior from an organization for which they serve. That is their sworn duty. But she's making comments that this is wrong, it was incorrect, it may break the laws, it appeared to be contrary, and so forth, or it could be a crime. Now, if she has those concerns, the appropriate measure is to take that to the council body and bring that before her peers to decide and raise those concerns and have them decide if further action and inquiry should be made to the auditor's office, or to first bring it to the official auditing body of the city, which is the 3 members that serve on the Finance Administration Committee. Again, not to embark upon her own. She's not a lawyer. She's not a scientist, as she said. She's not a lawyer. She's not a financial auditor. And, she doesn't have the expertise to make some of these conclusions. But aside from all of the malfeasance that she paints and the hyperbole around malfeasance and potential fraud and corruption in her judgments, what all that matters in the end is, what did the auditor conclude? And I would be happy to provide the ethics officer with the audit reports going back the last 3-4 years. We have had very clean audits. In fact, I think we just concluded 2019. There wasn't so much as a finding or a management letter, even with the hotline requests that were submitted on the issues that Councilmember Shepherd is alleging some really alarming things were taking place. The auditor examined those, found nothing to even issue a management letter on. And again, if the ethics officer would like those to be provided, we would be happy to do so. Lastly, on the timing and on the alleged inappropriateness of the mayor sort of overseeing the other branch of government, these are issues that in some way, look, the mayor, myself, or the other council members are not unaware of the profound difficulties of questioning the behavior and ethics of a sitting elected official. And so there's been a bit of probably it's just moving forward and on some of these issues, what came to head this last summer was Councilmember Shepherd bringing to our attention some communications she had on what was in the original complaint regarding the Soldana family on some concerns around how the police conduct.
Are we discussing that? I'm sorry, I thought that was.
It was dismissed, but it's
It was
relevant.
It was dismissed. So if you can just be very brief on that, Mayor.
Yeah, no, the relevance, Mr. Degginger, has to do with Councilmember Shepherd's comments about the timing, questioning my motives. And so that's very pertinent because it was communications that Councilmember Shepherd was having with that family on what could be a potentially litigious matter that really raised the concern of the council members. And so we asked if any further communications had been made, or she said there was other communications. And then that is when I directed the staff to look further into council members, some of her email contacts with various agencies. And that's why at this late date, when she's saying this stuff all happened a year or so ago, it was at a later date after this past summer or last summer when issues came to light, the most alarming of which is that she had set up an automatic protocol where city emails were automatically being forwarded to her private email on a regular basis, which would include. False. Well, the evidence would suggest otherwise, but and Councilmember Shepherd, I didn't interrupt you. If you could please respect and not interrupt me. That's I'm strictly speaking to the timing issue as to why these things came to light, and then we made further, and then it was the urging of unanimously of the other 6 council members. It was not just a request, but a pretty strong demand that action finally be taken, and the determination was given my office as the mayor that it kind of fell to me to be the responsible party to protect the integrity of the deliberative process, and that's why. As my role as a mayor, the complaint was brought forward by me. Yeah, so I think that concludes my comments.
Did you have anything else, Mayor?
Give me 1 second to just review some.
You bet.
Yeah, I think it speaks for itself when Councilmember Shepherd makes a comment like, I assert that the email does not warrant confidential or protection. Again, she doesn't have the authority to make such determinations on behalf of the city or the city council. Those concerns need to be brought to the full body or the full council to be addressed before making such a determination. As you can imagine, it would be pretty dangerous precedent to do otherwise. So, anyway, that concludes my comments. Thank you.
Okay, thank you, Mayor. I had just a couple of follow-up questions from your comments. One was, I'd asked Councilmember Shepherd if the Department of Ecology has a role in the mill site proceedings. I didn't get a chance to ask you what your understanding is there in that regard.
Well, I think they absolutely will have a role in oversight of a number of environmental issues on any parcel of land, whether it's developed or not, but certainly will when the project comes forward. Shoreline issues that are impacted by the development, and on-site drainage issues and wetlands, and a whole gamut of issues. And
what is the current status of the project right now?
We anticipate literally within a week or two that will come forward for some of the final deliberations with the council.
We haven't started.
Yeah, no one contended we hadn't started. Yeah, that's correct. We have not started the deliberations yet.
So the environmental impact statement has been issued and comments have been received. No. Is that right?
The final has not been issued.
Excuse me. I'm asking the mayor right now, and then I'll come back to you, Councilmember Shepherd.
Yeah, the draft environmental impact statement was issued. There were public hearings on that, took a great deal of public input, and then the applicant went back and has spent the last several months responding to all the issues in the DEIS. And now we're within a couple of weeks, we're anticipating that the EIS will be issued.
Okay. All right. And then I want to go back to one other matter, which was the stores complaint, which both parties have talked about, Mayor. I just wanted to get a sense of, there was an appeal filed, is that right?
I'm sorry, which issue again?
Stores complaint. There was a complaint filed in response to the approval of the Salish annexation.
Yes, and I think and again in great detail, Ms. Storrs describes the what information she acquired from Councilmember Shepherd and when and how that.
Right. And my question is focused on, and how, and that complaint was dismissed at some point in time, is that correct?
It was pretty quickly dismissed by the judge, yes. And in fact, to the point where the judge even awarded the city attorney's fees.
Okay.
In other words, we even attempted on numerous occasions to point out to Councilmember Shepherd that the legal description contained language that said it only includes this parcel west, or I forget it was west or east, or everything west of on this part. In other words, there was a large parcel, the 202 cut through it. The language said the development project only includes the portion of the parcel to the west of the 202. That critical sentence continued to be ignored and was very costly to Ms. Storrs and ultimately.
Okay. Just taking a look in my notes, see if I had any other follow-up questions.
Well, if I could further add on Councilor Shepherd's PowerPoint presentation, again, she goes over and over this issue of this neutral party, and I again contend that there is no definition or allowance for what's called a neutral party. That seems to be her invention. And again, she continues, she has not responded to the issues on section 2 of RCW 42.36060, which is the prohibition does not preclude a member of the decision-making body from seeking in a public hearing specific information or data from such parties relative to the decision if both the request and the results are part of the record. In other words, she can do all the research she wants, requesting of staff of the applicant, with ecology, with other agencies, with GIS, so long as those requests are made in a public hearing and on the record. Again, that's the difference between seeking information. It almost
Objection.
What's your objection?
Well, he's not recalling what happened correctly.
I'll let you respond briefly in a minute, but let him finish his
Okay.
thing.
Yeah, so again, that's the fundamental difference between if a council member wants to seek further information to help them make a decision, it's influencing the decision. So it has to be on the record. Anything they want to seek, they have to bring it into that public forum or public process, working with the staff, with the full council, with the applicant. So all rights are protected and everything is done open and transparently. It's different if you're receiving information. Again, passively receiving information, you can't control if people want to email you or stop you at the grocery store. But if that happens, you can quickly cure it by simply, stating those on the record and what the content of those conversations or emails were during the deliberations, when those deliberations begin, or if they've occurred.
Okay, Councilmember Shepherd, I'll give you a brief moment to respond.
So on October 22nd, I did ask for maps. In fact, I asked for maps prior to October 22nd, but it was during the hearing. And the staff, like a broken record, said, no, we cannot give you maps. And there were many very complex legal descriptions of property that were not understandable. And I had disclosed at that point in time that I had gotten something from the King County as far as the mapping of what was supposed to be an accurate description of that property. And I said, and it does not fit what we are describing. And so I asked the city if they would give us maps, and they would not.
Okay. All right.
Since that contention is not on the record, I would just say that or no evidence that she presents to that effect. That's not true. The maps were provided to the council. They were just not the maps that Councilmember Shepherd wanted to see, apparently. And even these issues of the boundaries or who was properly notified in this critical sentence I'm talking about was, again, part of the broken record.
Okay. All right. I want to thank both of you for your presentations today. It was helpful. Just to reiterate, Friday, close of business, Councilmember Shepherd will have a chance to do a brief response to the letter that was submitted by the city attorney. Mayor Larson will have an opportunity to make a brief response to what Councilmember Shepherd submitted today. And then we'll have the record closed and I will endeavor to get a response or an opinion prepared. And then also if by the end, would it be possible by Friday, Mayor Larson, I'm asking you only because maybe you can help facilitate, or somebody on your staff could help facilitate getting those 3 redacted documents recirculated to the
Thank you
parties.
for bringing that up. I was only going to ask of you, if you were taking notes and capturing that, if you could just summarize what specifically you're looking for.
Correct.
Make that,
Yeah.
and
It's
then I'll make
yeah.
sure we get those down and get those documents to you.
All right, I'll send an email and I'll circulate it to all the parties so that it's clear.
Thank you very much.
Right. With that, I think we'll conclude the hearing, and thank you for your time and attention today.
Thank you, Mr. Deginger.
Thank you.